government lawyer CLE that I've got this recording thing popped up here. Okay, I'd like to welcome you to the Government Lawyer CLE. We've been approved for 2.1 CLE credits. We will end around 2:00 p.m. And now's the time to leave if you found out that you're in the wrong Zoom portal, and that's happened before. So feel free to stick around, or if you're not where you wanted to be, you can certainly switch to another portal. I'm Martha Hill, and I'm the chair of the Government Lawyers Committee of the State Bar. And if you're not a member of the committee and you have an interest in this practice area, please join us. I will put my email and cell number in the chat in just a minute. So just contact me if you are interested in becoming a part of our group. We meet every other Tuesday at noon. We've been meeting by Zoom through the pandemic, and I just found out that on July 13th, when we have our next meeting, we are going to be permitted to meet in person at the State Bar Center. We will always have the option to call in or to Zoom in to the meeting. For the committee members who are on here today, I would like to call the meeting to order, and you should have received the minutes from the March 30th, 2021 meeting. I will not ask for approval at this time. I think that'd be a little bit chaotic. So I will table the approval of those minutes until our July meeting. And before we begin the CLE, I would like to thank Robert Wilson for his assistance in getting the CLE approved through the State Bar. Please feel free to eat your lunch, a snack, drink your coffee, your tea while we're having our CLE today. We're not going to take a break. I think it's a little difficult to get back on a Zoom when you take a break. You certainly, wherever you are, you can stand up and take a break and in your own environment, and we'll just continue to plug right on through the 2-hour or 2.1 hour CLE. If you have any questions during the presentation, please either put the question in the chat or just put in the chat that you have a question. There again, I think it's a little less chaotic to do it that way than to have 250 people all at once trying to raise their hands. So please just let me know if you have a question, and if you can identify which speaker the question is directed, that's great. If not, we'll figure out somebody to answer the question for you. The bios are in your packet, and I'm not going to sit here and read it to you. I will give you a little cursory introduction of each of our speakers. And the first speaker is going to be Christopher Ross. He is an active member of the Government Lawyers Committee and a member of the law firm of Pullen, Fowler, Flanagan, Brown, and Poe. As you can see, private practitioners are always welcome to our group. He's going to discuss a specific bill, Senate Bill 277, which was the COVID-19 Jobs Protection Act. Christopher?
Well, to be fair, I do a lot of government representation as well, so I try to keep my foot in the door. Let me get my screen shared here. I learned from the great Gary Pullen. Okay, can you see my screen? Okay, so there was a slew of bills that were passed, as there always are every legislative session, and Doran is going to go over most of those. I was asked to talk about this one because I did an article for Defense Trial Council West Virginia about it, and I believe this is one of the most significant bills that the legislature has passed in the last decade, just because I think it's going to have a wide-reaching application and effect. Let's see if I can toggle my stuff here. So as the year began, we saw about 30 states that had already passed legislation to shield certain entities from some or all liabilities related to COVID-19. Now it's about 38 that have done that. And of the remaining, about half of those have executive orders in place or have proposed legislation. Like Texas recently has some proposed legislation that's very close to ours in terms of how strong that it is. And then there are 1 or 2 states that have not passed anything. But right now, we have 9 states that have passed what West Virginia has passed, which is legislation that is retroactive in whole or part. The most recent one of those was Florida, which also has legislation that's very similar to ours. And Texas also is going to have a retroactive application to their statute. So looking into the statute itself, the statute is fairly broad, and in fact, there was little debate on it in terms of amending it. Every time that an amendment was proposed in committee or on the floor, if it limited it, the amendment was generally struck down. So the intention is clearly to make this bill as broad as possible to protect various entities for economic recovery. Um, the bill was passed by the legislature on April 1st, and it was signed by the governor on April 8th. But the effective date of the bill is January 1st of 2020. So it should cover, it explicitly covers any kind of cause of action, civil or criminal, that could be filed related to the provisions that are within the bill or that may have already been filed. So it has an intention to stop any suit that was currently in process. Now, I'm not aware of any at this point in West Virginia that were filed. There may be some out there, but most people were probably operating on the idea that we still had a statute of limitations of 2 years. But now that is no longer the case if this bill remains in effect in its full force. The first major part of the bill is that it bars any cause of action against any person, essential business, entity, healthcare facility, healthcare provider, first responder, or volunteer from loss, damage, physical injury, or death arising from COVID-19. Now, that's pretty much the kitchen sink approach. Even and person includes all the different things that you might expect to see, like educational institutions, healthcare providers, nursing homes are provided under a healthcare provider, essential businesses are covered by the governor's executive order. But it's very broad, and there are very few things that I think would not be covered under this. And that was one of the initial concerns on the bill, because there are no exceptions on this first part of the bill. And that is most states that have passed similar legislation for one or various sectors have passed a bill that has an exception for intentional torts, wanton negligence, or malicious intentional conduct, and that's not the case in our bill. It's a blanket and absolute protection. Now, there's a second part of the bill that covers manufactured goods and suppliers of those goods, people who donate goods that were supplies or personal protective equipment, or as we heard throughout PPE. And that does have an exception for those who act recklessly and outrageously with indifference or malice. And those are the kind of exceptions that we tend to see in the other states that have addressed this. But it's only related to manufacture, design, labeling, supplies, transport, selling. And I guess this would be the kind of case where somebody was selling defective masks or fake N95 masks, or in a case where somebody was selling hand sanitizer that didn't have the proper level of alcohol content to kill germs, which is something that we saw happening with consumer protection complaints in various states, including this one. And also there's a 1-year statute of limitations for somebody to bring suit under that exception on the manufacturing aspect. The third aspect of this bill is workers' compensation claims with employment. So, of course, the first part of the bill would cover most employment actions that weren't workers' compensation, like if you had a discrimination claim or some other claim that could be related back to arising from COVID-19, which is one of the concerns that was raised on the floor of the House when it came over to the House. Well, do we want to limit the scope of this so that somebody who maybe was drinking and driving, that was transporting personal protective equipment, would they be exempt by the bill? And well, we don't know. If it's arising from COVID, there's an argument there that they could be exempted from it if the malicious and wanton conduct wasn't related to the actual manufacturing. But with workers' compensation, this is one where my initial slide that went out with everyone's electronic notification for this meeting is wrong. There is no exception on workers' comp. In fact, the legislature specifically said that deliberate intent actions would be limited to whatever benefits are available under the regular workers' compensation claims. So where usually a deliberate intent action could remove a workers' compensation claim to the circuit court, that is not the case for workers' compensation claims. And there is something that's interesting about making everything go through workers' comp, and I don't know if this is an intended consequence or not, but generally speaking, in order to be a compensable occupational injury, there has to be a finding that it is something that is endemic to the workplace, like asbestos, silicosis, federal black lung or state black lung claims. There, if the an ordinary disease of life that is just as easily contracted by somebody going to Kroger's as opposed to being in the workplace, is not generally compensated. And there are some cases in West Virginia that talk about that and talk about the standard for which we would be looking at compensability for an occupational disease. And I think that in West Virginia and other states where this has been tested would find that it's not a compensable injury. So again, this bill is incredibly comprehensive in terms of what it's limiting. Now, there is one big exception, and that is that the act does not affect any duties or rights arising from contracts. The reason for that is because most states, including West Virginia, find that the legislative body cannot affect contracts that have already granted people rights, and that would be a constitutional challenge. We've seen those challenges in other states, and sometimes they've been effective. Now, it always comes down to what we're looking at with the contract. If it's a unconscionable contract, there might be another way to attack it. But this bill specifically does not affect contracts. And it has a severability portion, if anything, is found to be unconstitutional. Now, the real issue that we have here is, from my perspective, whether or not the bill can be retroactive. The West Virginia Code talks about that all bills are considered to be presumed to be prospective unless expressly made retrospective. And in this case, the legislature did very intentionally make the bill retrospective. The legislature can pretty much make any law that they want within reason going forward in terms of limiting people's rights or recoveries or access to the courts. But here we have the question of whether or not this legislation has intruded upon an established or a vested right or substantial right. And that's where scrutiny has to be applied, going back to the January 1st, 2020 date where this bill will be effective. There's no question that they can limit it from the time they passed it. But and I think Doran's going to talk a little bit about how when laws become effective in his presentation, so I'm not going to go any further into that. But the first case that I'd like to point out was a case that came after the 2015 legislative session, where the legislature changed some of the remedies with front and back pay. It's Martinez v. Esplenda. It came up in 2017. And here, the majority, 3-2 majority, with Justice Walker writing the opinion, found that statutory changes that are remedial will be permitted because they don't affect a substantive right that is vested. And here the court found that where the legislature put a cap on front and back pay and made a duty to mitigate front and back pay on the person who is bringing the cause of action, that was appropriate because the right did not vest at the time of discharge from employment, but only vested upon entry of judgment in the plaintiff's favor. So from their perspective, it was a change of the award rather than a change of the remedy. Justice Davis and Workman dissented. Justice Davis wrote the dissent that said that this is a very specific way that the court has found to justify the legislature's actions in what is essentially an ex post facto law that shouldn't be permitted under West Virginia's tradition. Well, and then interestingly, the court 2 years later in Goldstein v. Peacemaker Properties seemed to kind of come the other way. Now, the facts in this case are very convoluted, but it's essentially where there was a property with a gun range that was close by. Adjacent to the property, there was a noise ordinance for the county that the gun range didn't explicitly fall into, but then there was a statute that was passed that talked about whether or not this such a statute, such an ordinance could be enacted and be applicable. But a lot of the meat of this really didn't come down to whether or not they had a cause of action under the statute, but it came down to where it was dismissed on summary judgment. There were some discovery disputes, and the real issue was should the case have been dismissed where there were some awards of damages for violation of discovery in the case. So the court stretched a little to find that there was notice pleading where the plaintiffs had, in their complaint, as we all see, had claimed other such relief as is just and equitable. And the court found that that was not only asking for an injunctive relief, but was monetary relief was wrapped up into that, and that it was a notice pleading. Therefore, finding the vested property right, they found that retroactivity cannot extinguish that vested property right with that procedural due process. Again, Justice Walker wrote that majority opinion, and she was joined by Justice Hutchison and Justice Workman, I believe. And so the dissent was written by Justice Jenkins, joined by Justice Armstead, that found that this is not a notice pleading, that is not a vested property right, because as they did in the Martinez case, it's only prospective future relief, and it wasn't. It should have been pled as special damages, or something else that Justice Jenkins wrote. So what we have now is two different ways of looking at similar issues. Now, in one situation, in the Martinez case, we're looking at an award of damages. Here, we're looking at whether or not something was pled. But what we're going to have is the court seems to be a little bit at odds, and it will be interesting to see how it comes down, because Justice Walker wrote both opinions in those two cases. She was joined by Justice Hutchison and Goldstein and Justice Workman, who of course is no longer there. Now we have Justice Wooten, Justice Jenkins and Justice Armstead are both still there, and they're going to be very strong on the legislative side of things. So we really don't know what will happen if this issue comes up again. And I guess it really kind of depends on what type of case that it is. It will be a very fact-specific analysis. In general, in West Virginia, we don't allow entire classes of litigation to be extinguished by retroactive application. And so the question comes down to whether or not that's what's happening with this bill. And of course, there are different types of causes of action. There are nursing home causes of action. There are employment causes of action. There are public policy issues. In fact, many states that have enacted these strong laws have already started to roll back some of their immunities given to healthcare and hospitals and nursing homes. Connecticut had an executive order in place that the governor let expire, specifically sunsetted it in March of this year. New York actually had also passed an early retroactive law that prohibited suits against healthcare and nursing home facilities and hospitals, that they rolled back prospectively in August by new legislation. And just back in April, the governor signed a law that completely removed that protection, going back to the beginning of the pandemic, for people who wanted to have access to the courts for family and loved ones who they felt had suffered negligence in nursing home settings and healthcare settings. So I don't know if we'll see something happen like that with this legislature, or if Congress will act to preempt the field. But in our law, there is no sunset provision. It is from January 1st, 2020, now and forever. So I guess that's really what we're going to be looking at, is what kind of litigation landscape that we're going to have. I believe that the law as it is passed is one of the strongest in the country. And I think it will probably remain that way until we get the case interpreted by a case that comes up to the Supreme Court. So that's all that I have. I do have my presentation available. And if you would like to hear some of those cases I was talking about with the employment implications, but I can provide that to you if you send me an email or give me a phone call, or even if you check with the bar, they can get that for you as well. And thank you for your time. I'm going to let Doran come back and do his presentation before we, let me stop my screen share here.
It's done. You're good.
Okay, so before we I'll let before I do any kind of questions, I'm going to let Doran do his presentation. He has a lot to get through, and then if you have questions, if Doran can't answer it, then I'll try to answer it. Thank you very much.
Thank you a lot, Christopher. Right. If you will submit any kind of question you have through chat, or that you have a question through chat, that would be really helpful. I'd like to introduce Doran there again briefly because his bio is in your packet. Doran is also an active member of the Government Lawyers Committee, and he works for Legislative Services and Legal Research and Bill Drafting. He is an example of a government lawyer who's a member of the Government Lawyers Committee. Anyone who has an interest in this area of the law is certainly welcome to join this group. Private practitioners, government lawyers, retirees, whatever. But we're certainly glad to have Doran make a presentation. He generally does this every year for us to give us an update on laws that have been enacted in the past session that particularly are significant to people who practice in the government law area. So Doran, I will turn it over to you.
Okay. The materials that I understand were sent out, I sent out 4 documents and they were all merged into one with my bio and a couple, 3 other documents, which I'll be referring to in the course of my presentation here. Let me first share my screen. I'm looking for the chat window. Sorry about that. There's 3 documents along with my bio. The first, I'm not sure what order they're in. One is this code updates from the 2021 legislative session. That's what I'll be going through today. It's just basically trying to pick some statutes or laws that may be of interest or of note. I'm not going to try and go through all of them. The other documents as part of the package is this list, which is the complete list of all bills and joint resolutions that passed both houses. I put that together before the governor had acted on all of them, and so it was complete as of that time, and I'll address the rest of that in a minute. And then finally, there is this page of corrected article and section citations, which I will explain in just a second. Those are all part of one PDF file that you were sent. Let me try to okay, I see that let me do this. For some reason, I don't get to see the chat window while I'm screen sharing, but I'm going to go ahead and put this link in the chat. That's a condensed link. That goes to a OneDrive directory where you can download the documents individually. There's 3 PDFs in there.
Or in the chat settings, when you're screen sharing, if you go to the top of the screen, there's a little arrow up there.
Okay.
While you're in the screen share where you can view your chat window.
Thank you. All right, that's good. So that way I'll be able to see if there are questions. All right, so returning back to my my sort of outline for the session, let me go to the boring parts of this first, or the standard presentation. A few years ago when I did this and I droned on for 2 hours, a colleague tried to compliment me a day or two later, saying that I made it about as least boring as I could have. So I will attempt to maintain that high standard today. Overall, this year we had 239 bills introduced in the legislature. That's a typical number, down a little bit from last year, but that's typical for most recent years. Not everything that gets introduced is as a bill or as a introduced document is a law that affects the West Virginia Code. There are resolutions of various types. There are 198 bills this year that were introduced to authorize the promulgation of legislative rules. And there were 52 bills related to appropriations and dealing with the state budget and accounts. 282 bills completed legislation. Those actually became acts of the legislature. Of those 280, and the surprising number this year were 280 were signed by the governor. There was one bill that was vetoed, but it was sent back with suggestions by the governor. Legislature amended the bill to meet the governor's objections, and he then signed it. And then there were two laws that became effective without the governor's signature. One of the perennial problems we run into is that in the rush to get bills all passed, and they're going through various iterations, sometimes we end up having different acts amending the same statute. And this year there were 9 code sections that were affected by multiple bills. I've got them listed there. The first one, 1121-9, is relates to a gross income for personal income tax reasons. I'll explain that one a little bit. Otherwise, I'd like to tell you a little bit about how we in the legislative services handle these apparent code conflicts. I think if you were to look in Mickey's, they will pick a version of the statute that they believe is the one that applies. And that's based on this case decision from Wiley versus Toppings, which basically says that the last bill that passed should be the one that prevails. I think it's a little more nuanced than that, because you have to first determine if there is even a real conflict. The Supreme Court has from time to time dealt with different statutes addressing the same thing, and talked about when you try to harmonize those different statutes. They have not addressed what happens when you've got 2 enactments of the same statute. There's also an Attorney General's opinion that was issued in 2017 relating to a similar situation where there was an apparent conflict in the the 2 versions. What we tend to do is, although there's the Wiley versus Toppings case, we in legislative services don't believe that we have the authority to declare one version over the other. So in that case, on our website, we actually put up both versions with an explanatory note. In addition, sometimes we create new sections in the code and give those new sections new citation numbers. This year we had 6 new sections that were created, but there was more than one bill that used those same sections. That's the purpose of this one-page document that shows the section numbers and the statutes which use them. And in each case that I've got listed here, the second act, I'm sorry, not the statutes, the acts, the bills that enacted them as new. And in each case with these, the second one, the second bill listed has, the number has been changed by the House clerk, who has the authority to revise citation numbers. So they just increment them. With regard to the material there in the center of the document, there was one bill that had 3 sections they created under a new Article 63. And then Senate Bill 334 created a new Article 63 for needle exchange programs, and it had 10 sections. Well, 3 of those overlapped with the previous bill. So all 10 are now part of a new Article 1664(1) et seq. And then lastly, there's an additional one more statute relating to the Public Service Commission. And you see the additional, the new citation there for the second bill. Okay. The good news with the 282 bills that have completed legislation, there's no way I'm going to talk about all of them today. The bad news is that the ones I do talk about, I'm just going to give you kind of a cursory introduction. I'm mostly trying to bring these to your attention. And for those that you think may affect your practice, I hope I can give you links or other information to what more you need to check into. A common question involves, when do these different statutes or acts take effect? Under the Constitution, there's a default period of 90 days from passage. Although the legislature can alter that. They have to take a vote of 2/3 of the members, and that's 2/3 in each house. Most typically, what we'll see in terms of deviating from that is to make an act take effective immediately upon passage, or to set it for a date certain. Quite often, they will set certain bills to take effect on July 1st to coincide with the fiscal year and other kinds of proceedings that seem to turn over between June 30th and July 1st. But as we'll see, there are a couple of bills that were given effect to even later dates. And the other question is, what exactly is passage? A lot of people think that's the date that the governor signs it, or the date that it takes effect, or the date after 10 days elapses if the governor doesn't sign it. But the Supreme Court has held, and this has been a long-standing principle. You'll see the case citation here is from 1892. Passage actually relates to when it completes its journey through both houses of the legislature. When both houses have voted on it and approved the act, that's the date of passage. If you look on the legislative website for individual bills, you will see a date of passage listed. In a prior session, somebody asked me, well, what happens if the bill doesn't become effective? The effective date is set for July 1st, but within the bill, there's provisions for certain things that take effect June 1st or May 30th. And this case that I've cited here, State XRL Board of Education versus Melton, said that nothing becomes effective until the actual effective date of the bill. So there may be other dates, earlier dates in the act, but they don't mean anything until the bill itself takes effect. As I mentioned, there's a few bills that don't take effect until 2022. I've got 2 of those listed here. One is the merit-based personnel system within DOT. And then the other is the Anti-Discrimination Against Israel Act, which for reasons I'm not clear on, was voted to take effect July 1st of next year. And I'll talk about that bill a little bit later in the presentation. Again, if you want any of the documents as separate documents, you can go to the bit.ly link that I've put in the chat. Here's some My contact information is there. If you should find any errors on our website, particularly with regard to statutes, I want to tell you that this year more than we are actually managing to get the West Virginia code sections on the legislature's website updated at the time of their enactment. Some of the statutes that became effective immediately upon passage, there were a few delays in that, but you should now be seeing the code being updated within a day or two when an act becomes. We're trying to do 3 updates a week to the West Virginia Code, incorporating any new statutes that take effect then. That's the best we've ever managed to do. In the past, it's taken several months of months of handwork to get the code updated online. So into the the individual acts of the legislature. I mentioned that I was going to be doing this presentation to a professional instructor, and said, they asked what kind of materials I had, and I only said I've got this long outline. And this person told me, I can't imagine doing anything, any kind of presentation without some visuals. You need some visual appeal. So I'll see what I can do about that in the course of the presentation. First of all, I want to talk about joint resolutions. These are treated just like bills. They are not effective to change legislation. With joint resolutions, these are proposed amendments to the state constitution. And in each case, they have to be put to the voters at the next regular session of, not next regular session, next general election. So there were 3 that were passed this year. And so we have joint resolutions. HR 2 does exactly what the title says it does. It basically is a reaction to the Supreme Court's addressing the impeachment of Justice Workman back in 2017. And this one now says that it provides that courts will have absolutely no authority to interfere or intercede whatsoever in any impeachment proceedings before the House of Delegates or the Senate. There's a property tax modernization amendment, which has the legislature has tried to get into place for a couple of years. It finally passed this year as a resolution, and it will exempt tangible machinery and equipment, personal property as personal property directly used in business activity, tangible inventory, and personal property tax on motor vehicles. This is for a tax relief bill. Again, these have to be voted on, approved by the public in a general election. And West Virginia and Virginia were 2 states that have constitutional provisions prohibiting the incorporation of churches or religious denominations. There was a recent court case in Virginia that held that that was violated the free exercise of religion. And so West Virginia, in an effort to comply before we get litigated, has proposed this amendment to correct this, to conform to this judicial ruling, essentially. For some reason, among the legislative staff, legislation involving alcohol, the sales of alcohol and distribution of alcoholic beverages seem to be very popular. I don't know why. It can be a big debate among the legislators themselves, but a lot of the staff seem to be in favor of liberalizing the beer, wine, and liquor laws. You probably have heard of this. It went into effect May 10th. We had a comprehensive bill, HB 2025. There were some things that were liberalized about our sales of beer, wine, and liquor during the COVID-19 state of emergency, and they've decided, the legislature voted to enact these into law. Among the provisions, sales of beer, wine, and liquor may begin as early as 6 a.m. 16-year-olds may be employed in the sale and service of alcoholic beverages if they are supervised by someone over 21. There are cocktails to go and in-person or in-vehicle pickup for sealed beer and beer growlers, craft cocktails that are in a sealed container. And there are certain licensing restrictions, but this is presents new ways in which people can get one-offs of wine and cocktails, or growlers of beer and wine. There's also provisions for some direct shipping from brewers and distilleries to customers, retail customers. There are a lot of revisions to and dedicated provisions for the production and sales of hard cider. And then there's expansion of types of licenses. There's a private farmers market license, private wedding venues, private tennis clubs, sports stadiums, multi-sport complexes, and one-day charitable auctions, and certain fairs and festivals will now be able to have a license or pursue a license for the sales of beer and wine. This year, we had a lot of concern dealing with the role of the governor in appropriating federal funds during a state of emergency. The legislature has decided to, hold on here. Oh, I'm sorry, there is a bill that I added after the materials went out. That's HB 2014, 2014. And that relates to the role of the legislature in appropriating federal funds during a state of emergency. Basically, it limits the executive branch to spending $150 million, not more than that, in a state of emergency without appropriation by the legislature. It also requires that an annual consolidated report of federal funds be provided from the Secretary of Revenue, and provides a stopper in the unspent, regarding unspent appropriated funds, so that if there are federal funds that have been appropriated, but by the end of the fiscal year, they haven't been spent, that kind of places a hold on them and they have to be reappropriated. Also should note, the governor has broad emergency powers to suspend what are defined as, what are listed as regulatory statutes, and there's no definition on that. But this new law says it will not, that power to suspend those statutes does not extend to anything governing appropriation or the expenditure of public funds. So this was the legislature's attempt to rein in the governor and say that we're the ones who make the appropriations and decide where the money goes. There's a few new developments in criminal law. SB 392 created a penalty for impersonating law enforcement officers or officials. In this case, it previously was just a fine, but they've actually added significant incarceration time if somebody were convicted. A couple other statutes there listing just for your attention, relating to punishment for second and third degree felony. That's largely a bunch of semantic and fixes and updates. Catalytic converters is a response to the recent surge in the theft of automobile catalytic converters, and it basically requires some registration and inquiries by dealers in catalytic converters and getting them secondhand. They have to report and inquire about who's trying to sell it to them secondhand, in an attempt to control the people who are stealing them and then reselling them. There's new provisions under SB277 for inmate good time. Allows additional good time for meritorious service and completing certain optional. Whoa, there was some. Sorry about that video flicker there, folks. It also adds immunity from liability to divisions of customs and rehabilitation, corrections and rehabilitation personnel against claims arising out of some incorrect or improper calculation of good time. If you look a little bit further down in your list, HB 2888, relating to when contentions can be revived based on forensic scientific results. Basically, this statute defines the terms forensic science and forensic scientific evidence. It says that if there is a contention about certain forensic scientific evidence, it's not deemed to have been waived if the relevant scientific evidence exists that was not available to be offered to the petitioner at the time of the petitioner's conviction, or which undermines the evidence that was relied on at the trial, and there's a reasonable probability that this would result in a different outcome. So it allows for it allows for the contentions based on evidence that didn't exist at the time of a person's conviction under certain criteria and conditions. Under courts, we have the, everybody's heard about the new intermediate court bill, otherwise known as the Appellate Reorganization Act of 2021. Before the presentation began today, we were talking about, oh, I'm sorry, I see before I get into that, I've got a question. Can you correct errors in titles to bills? I'm not sure whether you're referring to these shorthand names that are given to the bills, which we actually call the short title. Those are assigned by the clerk of the respective houses of the legislature. There is also within a bill something called the formal title or the full title, which is a provision required by the Constitution. The title, a lot of times you will see at the beginning of a bill, a very exhaustive statement of all the sections that are affected and brief explanations of different matters that are contained within the bill. The question is, can you correct errors in the titles to the bill? The legislature can correct errors in the titles up until the point of enactment, but they cannot, the titles cannot be corrected after the bill becomes law, after it's passed by the legislature. If there are errors in the title, sometimes the governor's office will spot those and send the bill back to the legislature saying, I can't sign this because of the following errors I've noticed. This year, we didn't see any of that from the governor. Quite often, the governor's office is very strict on those, and we get a handful of bills every year. If a bill goes into law and it has an error in its title, maybe it omits talking about something, maybe it incorrectly references a matter within the bill. Usually what we find in terms of errors in a bill are errors of omission. The formal title of the bill simply doesn't speak to some provision within the bill. The titles don't have to be an outline of what's in the bill. They just have to give the reader some indication of what's being changed or affected by the bill. There's a lot of case law that has been developed over time. It's still, even with all that case law, it can still be hard to determine what is in what the courts will require. If there is a defective title, the courts will generally hold that the portions of the bill that are not referenced in the title do not have any legal effect. They will strike down those provisions and sever the provisions of the bill. I hope that answers the question that I just see was posted. Okay, so back to the intermediate court bill. As you may, if you followed it at all, you could see that this was proposed and it took different forms while it went through the legislature. Initially, there was a talk about having two separate intermediate courts, one for the northern part of the state, one for the southern. In the final bill, it was 3 judges. Initially, they're to be appointed by the governor, and the act is not specific as to how this court is to be held. It did, or where. It says that basically the court may be located in any county seat convenient to the litigants, or it could be located in a fixed location. I don't know if we'll have an itinerant court, but perhaps we will find a fixed location for the intermediate court for purposes of logistics. It'll be interesting to see how that is going to work, because the Supreme Court clerk is also to be the clerk of the intermediate court. So all matters, there's not a lot of specification in the act about where the clerk's office for the intermediate court is to be held, or how documents are to be handled. A lot of that will have to be dealt with by the Supreme Court itself in terms of rules of procedure and practice. The intermediate court doesn't have any original jurisdiction of any kind, not even in writs or certified questions, interlocutory appeals, none of that. It only this jurisdiction is defined as only appellate and judicial review. That covers final judgments in civil cases, judicial review, administrative decisions under the State Administrative Procedures Act, what is sometimes called judicial review of contested cases, but applies to any kind of administrative decision. It also will handle appeals from family courts and final orders from the Healthcare Authority and the Workers' Compensation Board of Review. There's no jurisdiction over criminal cases, juvenile proceedings, child abuse and neglect, mental hygiene commitments. Doesn't deal with lawyer disciplinary actions or judicial investigation commission, ethical violations of judges or lawyers. Nothing to do with the PSC. It does require written decisions, states that those are required as a matter of right. This bill also addresses several changes to provisions for workers' comp It does away completely with the office of judges, transfers some of their powers and duties to the Board of Review. Appellate jurisdiction over what has been the Office of Judges and Board of Review is now part of the Intermediate Court. It changes a bunch of the effective dates and the procedures, and establishes some procedures to effectuate the transition. Pretty much all of this is due to occur, although the bill takes effect June 30th of this year, it's considered to have a 1-year phase-in period to, or shall we say, to gear up. And that a lot of the actual provisions of the act, when the court, this new immediate court will assume its jurisdiction, is July 1 of next year, 2022. So there's a sort of a run-up period to enable the Supreme Court to work out some of the procedural issues and the logistics. Didn't see too much in the realm of domestic relations except for Senate Bill 78. And that now refers to, actually, there's another bill I'll talk about later about interest of the child in terms of domestic relations. But this bill simply refers to a list of factors in considering spousal support, and changes a reference from one portion of the code, which dealt mostly with paternity testing, to now factors to be considered in terms of what is a fair and equitable calculation of spousal support. There were several provisions in education this year. SB 14 provides methods for alternative certification of teachers. Basically, it says that if you've got a bachelor's degree and you completed certain pedagogical training, either a course or courses, and you pass a subject matter and competency test, you may obtain a teacher certificate. Previously, this shortens the amount of specific information relating to teacher and allows for other people who have obtained bachelor's degrees, regardless of subject matter, to become teachers if they meet some minimum standards in the pedagogical courses and they are able to complete a competency exam. We also have different provisions relating to funding. Oops, sorry. For education. One of these was the 529 prepaid tuition plan. This was sponsored by our state, an initiative from our state treasurer. It closes an existing 529 prepaid tuition plan and two funds that support it. It changes the it creates a different kind of prepaid tuition plan. The bill closes just the prepaid tuition plan, but there's the Smart 529 college savings plan that does continue. I'm sorry. And it creates a new special revenue account for this purpose, and allows up to $1 million to remain in the existing escrow fund for up to 10 years while that is paid down and paid out. SB 659 regarding free speech, free expression on state higher education campuses, it basically eliminates the concept of designated free speech zones and says that outdoor areas on higher education campuses are considered public forums. There can be some content neutral restrictions regarding time, place, and manner, but that's it. And they have to be content neutral. If there are activities that violate those kind of restrictions, they may be canceled, postponed, or terminated. But otherwise, expressive activity is allowed, and there's even provides for injunctive relief and actual damages for suppressing any of that kind of free speech. There's also the Jumpstart Savings Program that was created. It's like a 529 program, but the savings there go for expenses for vocational training. Employers may create a Jumpstart savings plan, or a person may create their own. There are a whole list of qualified instruction, qualified expenses, fees, tuition, tools, equipment, supplies, licensure or certification fees, and in some cases, business startup costs to go along with vocational training. Another bill that attracted a bunch of attention this year was the Hope Scholarship Program. That was House Bill 2013. This creates a list of qualifying expenses, again, fees and services mostly, tuition and fees for alternative education. I don't see books and other kind of school materials on the list, but it basically provides a way that if it's a person who applies and is qualified, and to be that, you have to be a West Virginia resident and must first have been attending a public elementary or secondary school. But once they get their award letter, they can attend other kinds of education, such as homeschooling. And this provides that they get funds more or less equivalent to the amount of money paid per pupil in the public school system. And the actual dollar amount is to be calculated based on the school funding formula, certain criteria in our standard school funding formula, and divided, apportioned among the number of qualified applicants. Another thing for the benefit of homeschoolers and alternative education programs is a prohibition about requiring in West Virginia institutions of higher ed, they can't require additional kinds of tests. In other words, if public school students' admissions criteria are measured by the ACT scores, then if a student submits a qualifying ACT score, the higher ed institutions can't ask for another kind of test. At least nothing that differs from the same criteria for admission of public school students. And then another hotly debated bill, HB 3293, is the one relating to single-sex participation in interscholastic athletic events. This is the transgender student bill. This took several different forms. In its final form, it pertained to athletic teams or sports designated for female, women, or girls. The bill makes several findings that, in fact, that biological males and biological females are not similarly situated. Classification based on gender identity serve no legitimate relationship to the state of West Virginia's interest. Those are among the specific findings by the legislature. And if a team or sport is designated for females, then they shall not be open to students of the male sex, where selection for the teams is based upon competitive skill or the activity is a contact sport. It creates a cause of action for any student aggrieved by violation of this, and it mandates the State Department of Education to promulgate legislative rules to carry out this new provision of the law. I'll take a brief break from my droning and see if there are any other questions at this point. I don't see any have popped up. Martha, have you gotten any?
Nope.
Okay. Moving along then. This year, we passed SB 368, which authorizes the DEP to develop a plan for dilapidated properties. This was proposed as one of several measures for the economic development and improvement of West Virginia. It declares the public policy of the state to establish a program to eliminate abandoned and dilapidated structures. It creates a fund that comes from an additional fee for a small additional fee for the disposal of solid waste across the state. The fund may be used solely to assist county commissions or municipalities in trying to get rid of abandoning or trying to get rid of these kind of structures by demolishing, deconstructing them, or whatever is proposed. The DEP is specifically directed to work with county commissions and municipalities and implement plan. A lot of this is planning based, development plans, redevelopment plans to prioritize action, create inventories of structures eligible, come up with proposals for reuse options for properties that may be in a high demand or high priority area, and the ability for the DEP to recommend to the county commissions or municipal governments what they can do or how they might take care of the abandoned or dilapidated structures that are causing problems in their area. This bill also contains some provisions for the closure of certain solid waste facilities. Let me say that although bills are generally to have one object under the Constitution, sometimes those are defined broadly in the course of their bill titles. So there may occasionally be provisions in the new bills that aren't necessarily reflected in the short titles that are given and that are listed on the website and in my my outline here. In fact, there are some cases, sometimes the short title tells you exactly what's in the bill or what it's about, and sometimes you have to read the bill a little more closely to realize that's not a complete description. There are several other statutes that I've got listed. There was a question that has popped up in the chat about the single-sex participation in interscholastic athletic events. Talking about the NCAA has threatened not to allow NCAA sports. I think it mostly relates to contests and tournaments in states that passed bills preventing transgender individuals from participating. And the question is, how will this affect Mountaineer and Herd football? Well, the interscholastic, let's see, I was thinking that the bill HB 3293 affects all levels of education, not just primary and secondary education, but the institutions of higher education as well. So that I'm sure if the NCAA has made threats and our bill regulates the activities for athletic teams at institutions of higher education, that will be of a concern to the NCAA. I've yet to see exactly this, what the NCAA is proposing. I think we're familiar with what they did about certain legislation in North Carolina a few years, and even moved some tournament venues. So no, I don't have an idea of how extensive it will be, but or if they will allow even other NCAA participant teams to play in West Virginia venues. Sorry, I don't have a better answer, but as far as I know, this will become an issue because the statute, the new statute affects all levels of instruction and including higher education. Other questions so far? Whoops. Several other bills there I've listed under energy and environment. If you have any questions about those. Some of these were intended to create parity with so-called green programs. There's the requiring of organic materials and commercial composting to comply with the West Virginia fertilizer law. That's SB 464. And there's SB 492. I should have deferred, which establishes a program for bonding to reclaim abandoned wind and solar generation facilities. This was kind of based on the idea that coal mines and other fossil fuel extraction facilities have to file bonds to show that they will be completely reclaimed and to guarantee that. So the question was raised, what happens when wind and solar farms run out of their usefulness? Will the proprietors of those kind of facilities be able to walk away without doing something? This law in SB 492 will require that they post bond to stay in business as a power generation facility. And then SB 542 requires a minimum amount of coal to be held on hand, 30-day aggregate fuel supply for public electric utilities. Other popular subjects every year with the legislature are, one of them is firearms. Because of the COVID-19 emergency, people began to think about what kind of issues may result in the declaration of a state of emergency. West Virginia legislature stepped forward and said that in no way, shape, or form are we going to limit, prohibit, restrict, seize, confiscate, authorize the seizure of, or require registration for firearms or ammunition, suspend licenses, freeze them, close or limit hours of firearms dealers, gun ranges, or in any way limit the quantities of firearms, ammunition, equipment, and supplies. So no restriction whatsoever during a declared federal or state, a federal or state declared state of emergency. In addition, another bill that got a bit of attention, there was a bill promoted as Economic Development Bill HB 2499 to give a tax credit to the to promote the manufacturing of small arms and ammunition. This has largely been described as a bill that exempts small arms and ammunition from sales tax. But the bulk of this bill is really related towards the manufacturing and the promotion of the industry of small arms manufacturing. One proposed amendment was to also include firearms safety mechanism, gun locks, and those kinds of materials, but that was voted down and did not make it into the final bill. For all you people that deal with FOIA law, there's a minor update to the FOIA law. There was concern that public utilities, such as in particular public service districts dealing with water and sanitation, have their customer databases, and if they are a public entity, couldn't somebody submit a FOIA request to get all the data about their customers? And so the FOIA Act was amended to exclude that kind of disclosure. There are certain exceptions in the law based upon actual need, but otherwise that is pretty much exactly what it says it is. Let's see, 120. This year, there were a lot of measures before the legislature dealing with the relationship between local government and state government. And in some cases, there was legislation that took over at a state level many things that may be handled locally. And the idea being to try and create uniformity across the state and not have little islands of local legislation that would make it hard for interoperability and application of laws on a uniform basis statewide. One of those in particular, again, arising out of the COVID-19 emergency, dealt with ways of making, as it was described in the legislature, making local health departments more accountable to their public. In this particular case, it means more accountable to local government governmental bodies that may control it, their decisions and their policies. In this case, the bill mandates the inclusion of non-voting ex officio members of whatever the local appointing authority is. So if you have a county commission that creates a county health department and appoints members to the local board of health, then some member of the county commission is going to be included as a mandatory member of the Board of Health as a non-voting ex officio member. It also provides for broader powers for removal of appointed members to those boards of health. If there are adverse determinations made by a local health department, that may be appealed. And this is said for the purpose of ensuring consistent interpretation of state public health laws and rules. It also creates a detailed rulemaking procedure for local governments that pretty much matches the state procedures for proposing and rulemaking. It actually requires local boards of health to publish their rulemaking proposals in the state register, just as legislative rules are announced there. So that will expand the duties of the Secretary of State, and in that respect, the idea is to provide more notice to the public of proposed rules. The governor may also dictate statewide policy and guidelines that are mandatory for local health departments. Martha had a comment, and I'll let her go.
Yeah, I was going to make a plug for the committee and give Dorn a chance to rest his voice. I know he's had a lot of information and doing a lot of speaking. Everybody out there, stand up. And no one can see if you're doing it or not. Just stand up. Okay, sit back down. If you're interested in joining the Government Lawyers Committee, please shoot me an email or a text. I've provided that information in the chat, and we would love to have you join us for our first in-person meeting in well over a year, which will be July 13th at noon at the State Bar Center. So with that, Doran, I'll turn it back over to you. And if you need a break again, just holler at me.
Another bill that received a lot of attention as it was moving through the legislature was Senate Bill S334. This relates to the needle exchange programs, the so often called harm reduction programs, which have, well, I think it's fair to say they've been very commercial, very contentious in several communities. This program, this law requires that all such programs have to be licensed. A needle exchange program will have to apply to OFLAC at the DHHR and must have a detailed description about the services they're going to offer, how they are going to make referrals to drug treatment programs. They have to receive letters of certification by the county commission and the county sheriff, and there has to be publication of notice in the local media. They must include what the statute terms a full array of harm reduction services, including the ability to track each needle that is given out, and requires a West Virginia ID for every participant. There are numerous reporting requirements, and the license has to be requested again every year. So there's only a 1-year period, and then they have to go through the full renewal of their license with all of that detailed information as required. You'll see some other bills there relating to the Physician Assistant Practice Act, HB 2005, regarding healthcare costs, regulates certain out-of-state healthcare providers and non-network facility-based providers. Essentially, this is a consumer protection measure. The idea is that if somebody may be treated and they're out of network, there has to be full disclosure of what the costs and what can be expected. There has to be a provision for binding arbitration of payment disputes and rules to provide for price transparency, publication of prices, and when an appointment is made, there has to be a provision of a disclosure of what kind of costs are going to be come from that appointment. This year, we expanded telemedicine to include interstate providers so that our Telemedicine Act isn't limited only to healthcare providers in West Virginia. The interstate providers do have to register with the state, however. And there's also provisions for audio only communications. They don't necessarily have to be a streaming in-person visit like we're having today. There's the at the end of the list under health there relating to Second Chances of Life Act. This has to do with specific notices to be given to a patient who's administered a chemical abortion in a 2-step process. There's one procedure involving the drugs mifepristone and misoprostol. And it requires certain disclosures to be made to that to the patient, including after disclosures to be made after the provision of the first medication, saying that the process is incomplete and it's possible to back out now and retain the life of the fetus. Under human services, we've got 2290, which creates an employment first task force. The idea is to create some kind of policy in which the first and preferred outcome of all publicly funded services that are provided to working age individuals with disabilities, the desired outcome is earning a wage through competitive employment. In other words, it's to promote the employment rather than other kinds of outcomes in the provision of services. With the 2260, that bill exempts the contracts for child placement services from the regular state purchasing procedures. And the emphasis is on performance-based contracting. In other words, the contracts have to have their requirements set forth in clear, specific, objective terms. There must be measurable outcomes, and payment for those services has to be linked to the performance. I'm going to kind of gloss over the insurance. Again, most of what I'm putting in this list is to let you know that there are bills out there. If you have questions about any of the specific ones, I will briefly address HB 2263. This is regulating pharmacy benefit managers. First of all, it requires quarterly reports to be made to the director of PEIA relating to claims, reimbursement, and charges. This is for any kind of pharmacy benefit services provided to PEIA participants. There are also provisions for the public at large guaranteeing minimum reimbursement levels, prohibiting certain kinds of discrimination such as steering, fee setting, or setting a cost based on patient outcome, prohibits limitations on choice of pharmacy, and also bundling of certain mandatory inclusion of services. Pharmacy benefit managers and health benefit plans, these provisions about the anti-discrimination and so forth cover any resident of West Virginia or relate to. Moving on to juveniles, the SB 562 is a pretty extensive act which governs all the process relating to determination of competency for a juvenile at any point in the juvenile process. There's a presumption that anyone under the age of 14 is considered incompetent. Those above 14 are presumed competent. And that's competency both from a mental health perspective and for purposes of participating in their legal decisions in their case. This statute creates extensive procedures for competency determination proceedings for when the respondents are 14 and older. There are timeframes established in the bill and qualifications for the evaluators of their competency. requires evaluation and competency attainment services to be performed in the least restrictive environment possible, given the child's best interests and public safety. And juveniles charged with an act that competency attainment services should not extend past the child's 19th birthday if it's they were charged with acts that would constitute a misdemeanor or a non-violent felony, and they should not extend past the age of 21 if it was a violent felony. SB 272, please. Okay, let me back up. Somebody has asked for question about SB 272. I will try to get to that one. Hold on just a second.
The question was asked if you have any particular bill left on Doran's list that applies to your agency or the kind of work that you do. Please put it in the chat. And if we don't have time to cover all the bills, at least Doran can highlight those particular areas. I noticed that Joan Parker asked a question specifically about juvenile competency.
Yeah, I missed that one. If you move down past juveniles, get into labor, there's the first thing under labor is the declaring work stoppage or strike by public employees. Again, this is a case where the short title doesn't completely or accurately describe the content of the bill. In this case, it is public employees in the educational system. It does not relate to all public employees, but school system employees. Work stoppage is participation is declared to be grounds for termination. Pay may be withheld for each day of participation. And it mandates that the 200-day minimum employment term for instructors and the 180-day instructional term for the students is still mandatory, and there can't be any waiver of those days just because there was a work stoppage. Moving on to, I was specifically asked about SB 272. This bill relates to the question of what's a contractor or what's an employee. And it was originally stated as we're trying to bring our employment law or employment worker classification in line with some federal standards relating to the IRS. There are several different definitions of who's a contractor or who's an employee for across different state laws, the Wage Payment Collection Act, Unemployment Compensation Act, so forth. So this is in part, it was an attempt to create a single definition. It includes a 4-part test. Worker signs a written contract with the principal in which the principal acknowledges certain conditions related to their services. The worker has to file, or if the worker has filed or is required to file an income tax return for a business or a self-employed entity for the fees resulting from the work, the worker actually and directly controls the manner and means by which the work is performed, and the worker satisfies at least 3 criteria from a list relating to the worker's ability to control their finances and behavior. That's a long list I'm not going to go through here, but if I encourage you to take a look at the specific provisions in that act. understand that it now creates one consolidated standard for all labor purposes in West Virginia. Question going back to SB 272 that I may not be able to answer relating to, oh, no, I'm sorry, not 272, but to the juvenile competency bills, the SB 562. Question is that retroactive, and how does that relate to the rebuttable presumption that a child under the age of 14 is incompetent? I don't have an answer to that. The effective date for that bill is July 9th of this year. I don't know that there's any language in there specifically about whether that's retroactive. I will say that in general, statutes which are to inure to the benefit of a defendant or a juvenile are to be liberally construed in favor of the individual. Though I used to do juvenile delinquency proceedings for many years, I don't have a good answer for that. If you want to give me a request by email, I will take a look and see what I can find out. I'll have to go back and read through the act. Under local government, several bills there, some of which we've already talked about. Again, I mentioned that the state seems to be looking towards, there's an interest in dealing with things at the state level rather than the city level or the local level to avoid creating islands of exceptions. If you look at HB 2500 and HB 2842, those are provisions that basically say local government can't regulate in this area. The auxiliary container relates to the regulation of cups, beverage containers, straws, etc. It's a reaction to some municipalities in other states outlawing certain kinds of containers or straws, and likewise preventing cities from banning certain utility companies or even power services that are generated by certain utility companies. The legislature decided to step in and preempt that from all local government, creating one standard for the whole state. Under professional licensing, the state is following in its latest trend to expand or relax some of the requirements for professional licensing. And so you'll see an expansion in certification of teachers, physician assistants. Under SB 372, there's approval of certain forms of graduate clinical training, both in this country and obtained in other countries. There's a sunrise process that is to be mandated for any proposal to create new occupation or professional licensing that has to go through the legislative auditor's office for a review on the need. There's a elaborate schedule of how things are to be, what level of regulation is required based upon. To me, this looks a lot like Judge Cardozo's famous negligence standard. The risk to be perceived defines the duty to evade. So with the legislation, the first question is, why is there a need for licensing or regulation of an occupation? What is the risk? Once you identify that risk, then the schedule tells you what's the most appropriate means to control that risk. Is it the free market? Is it some kind of monitoring? Is it merely registration? And again, there's a detailed schedule within the Act. The West Virginia Contractor Licensing Act moves what has been considered a vocational licensing for contractors of various types under Chapter 30, which regulates the professions. One considerable basis for this is the first article in Chapter 30 provides some procedures and principles that are applied to all professional licensing acts. And by moving the contractor licensing to Chapter 30, then any kind of changes to the general licensing provisions will also apply to them. It also, here's another case where it preempts local licensing. Counties and municipalities are not permitted to require licensing of electricians or building contractors of various types. I do want to mention under state purchasing and contracting, SB 280, which relating to e-commerce modernization, it basically says that all all political subdivisions have to have an online system for receiving payments for their fees, services, and fines, penalties, any kind of monetary payments that the local government may require. And I do mean specifically local government because it says all political subdivisions. So that would apply to counties, municipalities, towns, public service districts. All of them have to be able to accept online payments by March 1st, 2023. SB 587 should be of great importance to all of you that work with purchasing on the state level, whether as a purchasing agent in dealing with contracting and purchasing procedures for an agency, or representing vendors dealing with the state. A lot of you may know about the famous WV96 form, which is a standard addendum designed by the Attorney General's office to disclaim a lot of things that are contrary to state law. SB 587 articulates in one specific source a bunch of provisions that are considered unlawful under state law. Those include many of the things that are in the WV96, provisions about choice of law, provisions about prepayment, and many things that are ordinarily disclaimed with the contract with the state. Those are now declared void, and any contract that has those provisions is declared void ab initio if it contains any of these prohibited provisions. It also says that this can't be waived. No official or employee or representative of the state has the authority to contravene it. So you can't just waive it or look the other way. I was concerned about the language that says the contract is void ab initio. Well, it's actually severable. Only the prohibited language is void. The contract is otherwise enforceable as if it did not contain the prohibited clause or provision. Recently, we've seen a lot of conflict in the news about or a lot of contention in the news in various groups about the conflict in Israel involving the the West Bank territories, and those who are pro-Israel, pro-Palestinian, or unlabeled. This act, which was voted on by an overwhelming majority of members of the legislature, prohibits public entities from contracting with any company that, unless the contract includes a certification that the company does not promote and does not boycott the state of Israel. There is a limitations on this. It does not apply to contracts that are of a value of less than 100,000 or to companies with less than 10 employees. An unusual thing about this particular statute is it was made effective as of July 1st next year. I'm not sure what the rationale was, but that was specifically approved by the legislature for that date. Some of you may be interested in legal liability and torts. The Consumer Credit and Protection Act. This establishes a list of 12 factors that for the award of attorney's fees. So a lot of it relates to the award of attorney's fees, factors to consider. It also gives merchants or businesses a 45-day right to cure once they've been notified of an issue. There is a detailed procedure relating to offers of settlement, when those can be accepted, and a rejection of the offer may bar collection of attorney's fees if the case goes to trial. There can be a separate proceeding on any issue that is alleged, any claim or defense that is alleged to be frivolous. That can be a bifurcated proceeding. I'm not going to talk about the safety belts unless there's a specific question. Chris has already talked about Senate Bill 277, the COVID-19 Jobs Protection Act, and relating to the filing of asbestos and silica claims, HB 2492 creates new criteria for some sworn information forms that have to be submitted with claims for asbestos and silica illnesses. Form has to be filed within 60 days and specifies detailed evidence regarding each claim, the products to which the person was exposed, the manufacturer of each individual product, the specific manner of exposure, dates and frequency of exposure, and the specific disease resulting. So that's a case of more detailed requirements required to be submitted with each claim at the time of the filing of the claim. There are a bunch of different tax bills. In particular, I'll talk about a few of these. SB270, that's a way you know about Booking.com or Trivago and Priceline. Those kind of facilitators that get rooms, they're kind of a reseller of vacant rooms. This was an attempt to collect tax from those providers. If you were book a room through one of those providers and go to your hotel, they may not be able to address any kind of refund or changes to your fees because that's not handled by the hotel itself. It's a reselling of a vacant room, and therefore taxes are often not collected at the hotel checkout desk. SB 532, limiting claims for state tax credits and rebates. Again, what does the short title relate to? In this case, it's only about capital investment used to qualify for a state tax credit. Basically, this says you can't get more than one state tax credit out of your capital investment. And it provides a procedure for the tax department to recoup some of the costs and fees if somebody has managed to make a double claim. And then under SB 693, the most important thing about this is it's the one that allowed people to, amended the definition of what's considered gross income based on the federal definition of gross income, incorporating changes that were made in federal law on or before March 12th of this year. In other words, the big relief package that was passed by Congress that allowed the federal tax filing date to be postponed to May 17th also applied to West Virginia and allowed West Virginians to wait until May 17th to complete their taxes. Or if they had already submitted their taxes, they could, and they got certain benefits, including part of that related to the first $10,000 of unemployment compensation was not treated as taxable income. So people can now file amended tax returns to recoup some of that money if they had already filed their tax returns before this bill became effect. And it did go into effect in April 2nd of this year. And then I'll move on to a couple of things about tech, e-commerce, and modernization, some of which I've already gone into about the local governments. There's an increasing trend with the legislature. Are we going to require notices to be published in the newspapers here in the 21st century, or can we do electronic notices? At this point, there's concern that not enough people have broadband capabilities, so there are still going to be requirements for publication in newspapers. However, you're not going to see the big long list of everybody's name who may have some unclaimed property in the treasurer's office. The treasurer's office now just publishes a notice twice a year saying, this is what we do. It's a possibility that if you're out there, you have property in our office that you can claim. And it will eliminate the very large advertisements. The DMV now can use electronic means to notify people regarding their licenses and let's see, in certain proceedings involving licenses and registration. It says that service may be affected by electronic means, and it's complete upon receipt of by the Division of Motor Vehicles of the evidence of electronic notice access. If there is none, then written notice is to be sent after 4 days. I also put in a bill there relating to, let's see, where did it go? SB 483. That actually is a little confusing. That actually relates to provisions relating to personal representatives, executors, or administrators of small estates. The bill that I meant to include in there is SB 469, which this is another one that came out of the COVID-19 law response. Too many cases, our statutes require the personal appearance before a notary. We've now moved to allow a notary to perform acts using communication methods such as streaming appearances. So you no longer have to make an in-person appearance before a notary. Let me I'm not going to go into any of the other bills here other than HB 2763, cyber incident reporting. That's going to require all state agencies, all local government entities, county boards of education, and other government entities to report cybersecurity incidents. There's a state cybersecurity office. They've got to create a criteria for reporting incidents, and they're going to have to develop and disseminate information about incidents and reports to people that may be concerned by cybersecurity issues.
You see Rebecca Tender's question?
Okay, no, oh, okay, sorry about that.
Rebecca wants to know the effective date of the
Okay,
notary.
notary change. Oh, just a second. Good question. June 17th of this year. Are there any other questions? Oh, what is the amount of small estates in SB 80? That's a good question too. I'm going to put my contact information into the chat window. And then on that, the term small estate was used in the statute, but when I actually went to the bill, it was more about having to deal with people that died intestate. Let me see if I can get that information. Estates where there have been no qualifications. The Small Estate Act, small asset means any probate personal property or assets of not more than $50,000 in value. Small estate means probable estate of a decedent who died in, who was domiciled in the state. Total aggregate fair market value of assets does not exceed $50,000. Total aggregate fair market value of real property does not exceed $100,000. And there's a presumption of what the value of the current assessed based upon the current assessed value. And that is in the new statute 44-1A1 at SEEK. And that's where you'll find the definitions.
Thank you so much, Doran, and thank you, Christopher. Everyone, you should be receiving an email from the State Bar and just follow their prompts as far as getting credit for the CLE today. Thank you all for participating, and particularly, like I said, Doran and Christopher. Okay. See you all soon.
Thank you.
Thank you all.
Nice work, everyone, if you can hear me.
It's amazing how quickly people drop off of here, you know?
Yeah. All right, Martha, good to see you.
Good to see you. Well, I don't see you, but I see your name.
Oh, okay. All right, good. All right, yes, they have me, I guess they have me, I cannot start my video, but anyway, all right, Michael Bevers here.
I see your name and hear your voice.
So. Oh, yeah, okay. Okay, very good. All right.
See you in July, I hope.
All right, I hope so. Take care.
You too. Bye-bye.
Well.
Martha, this is Mark McCohen.
Yes, sir.
My screen has shrunk down to only you. It's about 2 inches tall, and I have no way to exit. So I need you to turn me off.
I will do that. I will see if I can turn it all off.
Okay, thank you.
Okay, take care, Mark.
Bye.